given in judgments of the Supreme Court, in law. So the question therefore is, can Parliament, which is operating at the same level, law, co-equal, can Parliament make, in the context of Article 191, and this goes to Section 8 of this particular law, can it make a law overriding in relation to the practice and procedure of the court, judge-made law, which is at the same pedestal? Can they do that?
No, they cannot.
Seems to me that even if we literally look at Article 191, perhaps it is unconstitutional.
या सब फिर अगर आपको कोई दलाइल नहीं देना है और नहीं सुन लीजिए ना, आप तो हर के जवाब ही दे रहे हैं, तो आप अपनी पिटीशन तो आर्ग्यू नहीं कर रहे हैं, मुझे नहीं लग रहा है। आप कोई दलाइल आप दलाइल देके ख़त्म कर रहे हैं, फिर आपसे सवाल पूछ लेंगे, आखिर में हमारे जहनों में होंगे, ठीक है, या हम अपने जजमेंट्स में लिख देंगे, हर जज अपनी राय लिख देगा अपनी मर्जी से। आप प्लीज अपने दलाइल दीजिए।
May I proceed on?
जी प्लीज।
I'll only make one observation. It is settled law by law that the Parliament has the power to make our judgments ineffective, and this is a precedent which is embedded in our constitution.
If they are lawfully empowered, if the Parliament is lawfully empowered, not otherwise.
फिर आप बहस करने लगे।
But surely that
आप सुन तो लीजिए ना बात को, फिर आप नोट कर लें भाई, आप आर्ग्यूमेंट्स तो दें, आप जज नहीं हैं, आप हर चीज का वैसे जवाब दे रहे हैं।
May I proceed?
प्लीज डू सो।
आपको इसके एक जरा supplemental
आप चलें, शुरू कीजिए, बिस्मिल्लाह कीजिए।
My learned brother asked you, surely that rule that Parliament can override judgments of the Supreme Court does not apply to a judgment which is interpreting constitutional setting or interpreting the constitution or setting or establishing constitutional law. That only either can be done by constitutional amendment or if the court itself revisits that view. I thought that was also settled.
Yes.
So देखिए साहब जरा एक क्वेश्चन, आपका कहना ये है कि 3 members अगर बैठ के बेंचेस बनाएंगे एज पर दिस लॉ, तो ये इंडिपेंडेंस ऑफ जुडिशरी पर के खिलाफ है। तो क्या हम 17 जजेस बैठकर जब रूल बनाएंगे, हम कोई ऐसा रूल बना सकते हैं जो जुडिशरी की इंडिपेंडेंस को लेके एक शख्स के हवाले कर दे, या ऐसा रूल बनाएं जो कॉन्स्टिट्यूशन के, क्या हम ऐसा कर सकते हैं?
सर कर तो सकते हैं, आपने अगर एक बंदे को
अनलिमिटेड पावर्स है।
My lord,
नहीं, just one minute. May I request my brothers, इनको बहस तो करने दीजिए, हम सब सवाल बाद में कर लेंगे। आप प्लीज अपने हिसाब से अपने आर्गू कीजिए।
Mr. Siddiqui, if I may just add, it is not a question of ये law गलत है या ये law बुरा है या अच्छा है। So fundamental question here is of competence.
Yes.
Who is competent to make whatever it may be called the rules of the law? If
ये तो आपने आर्ग्यू नहीं किया अभी तक।
तो मैं ये तो कह रहा हूँ,
आप हमें रोकें, आप क्या मुझे आर्गुमेंट सुन लीजिए।
मैं तो कह रहा हूँ कि कॉम्पिटेंस नहीं है पार्लियामेंट।
आप बताएं ना, हमें शिक दें कायरीन की।
डायरेक्ट उसी पे आ जाए, मेरे ख्याल में
इसी पे आ जाए, यही सवाल है।
देखिए मैं आप देखिए, आप हमसे ज्यादा समझते हैं, वकील हैं, यकीन हम लोगों की अपनी अपनी राय हैं, ठीक है।
मुझे आप
जरा सुन लीजिए ना 2 मिनट जी। वो हम अपने, अगर हम एक दूसरे से इत्तेफाक नहीं करेंगे, अलग अलग राय लिख देंगे, ठीक है। मेरे हिसाब से मुनासिब नहीं है कि हम सवाल के तौर पे अपनी राय आपको दें और फिर कोई हम दूसरा जवाब दें। हम सिर्फ सवाल पूछ रहेंगे आपसे, आखिर में आप अपने दलाइल दे दीजिए, हम उसको नोट कर लेते हैं। हमें पसंद नहीं आए तो फिर हम सवाल, इतने पसंद आए शायद सवाल ही ना पूछें, नहीं पसंद आए 2-4 सवाल पूछ लेंगे। अब आप बिस्मिल्लाह कीजिए जी।
Lord, the concept of trichotomy of power is a concept well known to your lordships. The Constitution, what are those provisions which relate to the trichotomy of power? And let us have a look at them. With reference to the Supreme Court, have a look at Article 176, my lord.
जी,
Article 176.
जी पढ़िए।
Lord, Article 176 says, the Supreme Court shall consist of a Chief Justice, to be known as the Chief Justice of Pakistan. And so many other judges as may be determined by Act of Majlis Shura, Parliament, or until so determined as may be fixed by the President. What this article says is that one of the first steps is the appointment of the Chief Justice. He is the centrifugal force, he is the linchpin, and once he is appointed and the rest of these members are not appointed, the Supreme Court will be there. And then the judges will be appointed.
Please, chaliye na, don't state the obvious, it's written there. This is
आप-
really,
आप-
no,
यही तो
sorry
कि
to
मुझे
say,
अफसोस हो रहा है।
आपको पता है अवाम कितनी पैसे खर्च कर रही है?
सर,
हमने
मैं
ये आप
अवाम की
ऐसी
खिदमत के
ऐसी
लिए-
बातें तो ना करें हजूर।
सर, आप मुझे आर्ग्यू, आप एक तरफ कहते हैं आर्ग्यू करें, दूसरी तरफ आप मुझे
आप कह रहे हैं ये आपने पढ़ लिया।
I am interpreting, I am just
Don't
giving
need
your
interpretation of the obvious. Supreme Court comprises of Chief Justice and Judges of Supreme Court. Obvious.
No, it is not.
It's not.
It is not.
But
I am giving you, your lordship, a circumstance that let us assume, to understand the dynamic of Article 176, that assume there is a Chief Justice and there is no other judge. The question is, will the Supreme Court come into existence? The answer is
I
yes.
will not answer your question.
It
We are
will-
not
I
here.
am answering-
We
I
are
am
not here in a
answering.
theoretical realm. Please don't. No, now this is
will.
not fair. We are not here in a theoretical realm to
us
discuss
proceed
what
for-
may or may not
Let
happen.
us
We are
proceed-
faced with a particular law. You challenge that law. Argue that case.
Let us proceed further. Let us go to Article 87. Article 87 relates to the Parliament and the Senate. Each house shall have a separate secretariat. This provided that nothing in this clause shall be construed as preventing the creation of posts common to both the houses. Sub-Article 2, Majlis Shura Parliament may by law regulate the recruitment and condition of service of person appointed to the secretarial staff of either house. Until provision 3, until provision is made by Majlis Shura under clause 2, the Speaker or as the case may be, the Chairman may with the approval of the President make rules regulating the recruitment and conditions of service of person appointed to the secretarial staff of the National Assembly or Senate. So this is the rule-making power. Let's go to Article 67.
I will not allow it, and I might even start imposing costs. Let's go here, let's go there. What's the relevance of Article 187? Don't do this to us. Sorry, please don't do this. Please don't do this.
It shows that the Parliament as a separate organ of the state
Profound.
as the power to make rules for its internal working. And this is the theme which is contained in Article 67.
No. ये रूल सिर्फ बनाएंगे किसके लिए? सेक्रेटेरिएट
हमने तो नहीं बनाए लिए।
के लिए,
Constitution-
रिक्रूटमेंट के लिए और उसके लिए तीन चीजें लिखी हुई हैं साहब।
सर, मैं आपको शो ये करना चाह रहा हूँ कि पार्लियामेंट का अलग सेट ऑफ रूल्स है, एग्जेक्टिव का अलग है, सुप्रीम कोर्ट का अलग है, और ये रूल्स जो हैं
आप
ये
सुप्रीम कोर्ट वाले पे आ जाइए ना। हम पार्लियामेंट के रूल्स जब वो चैलेंज करेंगे ना आप कि उन्होंने गलत बनाए, वो देख लेंगे। अभी आप सुप्रीम कोर्ट पे आ जाइए बस।
सुप्रीम कोर्ट के रूल्स हैं आर्टिकल 191।
उसकी तशरीह कर दें, खत्म।
Subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now, the law is a word which is different from the act of the Parliament. It may.
Law is different from Act of Parliament.
Yes, it is. Law is
So
a
this is something I've never heard before.
Yes, sir. Allow me to assist you. Law encompasses a lot of other things than the act of the Parliament. Law includes with it itself usage having the force of law. Refer to Article 8.
In the same sentence, the Parliament Ain has used Constitution, law, and rules. And please, I'm not going to expect this kind of argument for the Supreme Court. Sorry, this is not on.
I am
नहीं
giving
देखिए
your
आप
lord-
ऐसे
no, I'm
arguments ना
giving your
कीजिए.
lordship extraordinarily good argument. If your lordship is inclined to ridicule me like that, I will not. I will withdraw from the case. I don't. I don't. I don't allow this.
Please, that's your choice.
Your lordship has constantly thwarted my arguments again and again. Have a patience to hear my arguments.
ये बताइए जो बेचारे लोग जेल में पड़े हुए हैं ना, एक छोड़ेंगे नहीं हम.
मैं बचा रहा हूँ, मैं से हूँ.
हाँ नहीं,
मैं भी नीचे से
केसेस कौन फैसला करेगा? एक चीज होती है अमेरिकन आइन में, वो लोग करते हैं क्या होता है, फिलिबस्टरिंग, कि जी चलते रहो. अगर आप समझ ही रहे हैं कि इस तरह से
मैं ऐसा कर ही नहीं रहा.
अब
अभी आपने मुझे
अब आप बोलने, आपको हम सुनते हैं मगर आप हमारी बात को सुनना पसंद नहीं फरमाते हैं. तो ये देखिए
बात आधे घंटे से सुन रहा हूँ.
चलें.
If I've got you correctly, if I've got you saying that law is not only the act of the parliament, because there are rules of 1980. If there were no rules, fine, they could have enacted that law. Because they have the rules of 1980, so that's why they were not empowered to pass any law which was contrary to it.
I would not go to that extent. Assume there are no rules. The question is whether the parliament can frame this law or not is a question which probably is not free from doubt. I would still say the parliament can't do it. Rules are imperative. If your lordship would look at Article 8, if your lordship would look at Article 8.
इम्तियाज साहब,
Sir.
ये सिंपल हो गया है. आप ये कह रहे हैं कि इस आर्टिकल में एक्सप्रेशन लॉ जो इस्तेमाल हुआ है, this excludes an enactment of the parliament.
No, my lord, I'm not saying this at all. I say law has a larger composition than the act of the parliament.
So we are, at this moment, we are only concerned with an act of the parliament.
Your lordship has asked me a question, what is the scope of the word law? And I'm trying to assist your lordship.
In this case, it's not relevant because the law has already come.
My lord,
आपने सिर्फ
I am saying that this law, your lordship's assumption is that since the word law has been used in Article 191, therefore the parliament can make this law. I am trying to show to your lordship it is not the case.
I'll take you back to my original question,
Please, lordship.
where under a constitutional power, this court has framed rules. Do they stand on a higher footing than ordinary legislation?
Yes, my lord, there are judgments to that effect rendered by your lordships.
Can I ask a question as well? When the Constitution makes a distinction in different articles using the Act of Parliament and using the word law, so how do you see that distinction? So for example, in 191, they could have said subject to the Constitution and Act of Parliament, but instead of saying that, they've used the word subject to the Constitution and the law. There are other provisions of the Constitution which don't use the word law, but use the word Act of Parliament. So there is a clear difference between an Act of Parliament and the word law. So what do you understand by the word law? Because this provision of making rules is subject to the Constitution and the law.